Gun laws are confusing. They're different in every state, and they change more often than your favorite streaming service's terms and conditions. Just because you have a concealed carry permit doesn't mean that you can carry everywhere, at least not yet. The American people deserve and they have the right to defend themselves, and that's what we're fighting for. Federal judge suspends key provisions of New York's new gun laws. The judge said key parts of the law are unconstitutional. Like the Fourth Amendment to the United States Constitution is supposed to protect each and every one of us from unreasonable searches and seizures. A single federal judge just did something no court in American history has ever done. She declared an entire state's carry permit system unconstitutional, and she did it using evidence from 1791 that gun control lawyers had absolutely no answer for. But here's the part that should make every gun owner in America pay very close attention. This ruling doesn't stop at New York's border. The legal framework coming out of this decision is already being weaponized in brand new federal lawsuits targeting California, New Jersey, Hawaii, Illinois, Massachusetts, Connecticut, and Maryland. If you carry legally in your home state, and you've ever wondered why that right evaporates the second you drive across certain state lines, what just happened in federal court is about to change everything you thought you knew about reciprocity in America. Let's get into exactly what happened, because the details of this ruling are far more explosive than the headlines suggest. Federal Judge Catherine Pogba didn't just take a passing glance at the Bruen decision and call it a day. She went deep. We're talking colonial-era records, territorial law archives, founding-era legal documents stretching all the way back to when the Second Amendment was first ratified. And what she found in those records is the kind of historical evidence that makes modern gun control arguments collapse under their own weight. The core question the court set out to answer was straightforward. Did early American governments restrict the right to carry firearms based on where a person lived? Did residency determine whether you could defend yourself while traveling? The answer turned out to be devastating for New York's legal team. Not only did colonial governments fail to restrict carry rights based on residency, they actively went in the opposite direction. The court found documented cases out of Pennsylvania and Virginia where colonial authorities explicitly recognized that travelers retained the right to carry weapons for self-defense regardless of which territory they came from. The founding generation treated the idea of disarming travelers moving between territories as one of the very tyrannical practices the Revolution was fought to end. British authorities attempting to strip colonists of arms as they moved between regions was viewed as an act of oppression, not reasonable governance. And the historical evidence gets even more damaging for the anti-gun side when you look at what the court called negative historical evidence. These are instances where colonial and early state governments had every reason and every opportunity to impose residency-based carry restrictions during wartime, during periods of civil unrest, during genuine public safety emergencies. And they specifically chose not to. They regulated where you could carry. Carouses were off limits, legislative chambers were restricted, certain government buildings had rules, but they never, not once, created a system where your fundamental right to self-defense disappeared simply because you traveled from one territory into another. Under the Bruen framework, this kind of negative historical evidence is absolutely lethal to modern restrictions. The logic is simple but powerful. If historical governments facing serious threats to public order still didn't impose residency-based carry bans, then modern governments claiming far less justification cannot impose them. Now, the judge applied what's called analogical reasoning from Bruen, looking at the general principles behind historical firearms regulations rather than demanding exact historical matches. And the principle she extracted is one that reshapes the entire legal landscape. The right to carry for self-defense travels with the person. It is not anchored to geography. If you had the right to carry in your home colony, you carried that right with you when you crossed into the next colony. That was the founding era understanding. And New York's current system, which recognizes exactly 0 out-of-state carry permits, violates that principle at the most fundamental level. But the historical argument, as powerful as it is, isn't even the most strategically important part of this ruling. The equal protection analysis is where this decision transforms from a single state victory into a nationwide legal weapon. Judge Pogue FIA ruled that New York's residency requirement creates an unconstitutional classification under the 14th Amendment. The logic is clean and almost impossible to argue against. Take two Americans standing side by side. Both have carry permits. Both passed background checks. Both completed required training. Both met every legal requirement their respective states demanded. One lives in New York, the other lives in Florida. The New York resident can legally carry. The Florida resident commits a felony by doing the exact same thing. Same firearm, same level of vetting, same constitutional right, completely different legal treatment, and the only variable is a home address. That kind of classification triggers strict scrutiny, which is the highest and most demanding level of constitutional review courts can apply. Under strict scrutiny, the government doesn't just need a good reason for the restriction. They need to prove a compelling state interest, and they need to prove they're using the least restrictive means possible to achieve that interest. This is a legal standard that gun restrictions almost never survive, and New York got absolutely demolished trying to meet it. Here's why. New York's primary justification for refusing reciprocity was public safety. Their argument boiled down to the claim that out-of-state permit holders represent a danger that the state needs to protect against. The court responded with FBI crime data showing that out-of-state carry permit holders commit violent crimes at a rate of 0.03%. To put that in perspective, that makes them statistically safer than off-duty law enforcement officers. The entire foundation of New York's argument that these people are dangerous was contradicted by the government's own data. And even setting aside the compelling interest failure, New York couldn't satisfy the least restrictive means requirement either. A total ban on out-of-state permit recognition is the most extreme possible approach. The state could verify permits. They could require additional background checks at the border. They could implement dozens of less restrictive alternatives. Instead, they chose the nuclear option of blanket prohibition. And the court ruled that approach unconstitutional on both prongs of strict scrutiny. The strategic brilliance of combining Second Amendment and equal protection claims in the same case cannot be overstated. For years, carry cases were fought almost exclusively on Second Amendment grounds, and hostile courts could find ways to sidestep those arguments, but equal protection claims operate on completely different constitutional terrain. A court that might be skeptical of expansive Second Amendment readings still has to grapple with the 14th Amendment's guarantee that all Americans receive equal treatment under law. You cannot maintain a system where constitutional rights exist for residents but vanish for visitors without clearing the highest possible legal bar. Gun rights attorneys now have a constitutional pinseer movement attack from the Second Amendment side and the equal protection side simultaneously. If a court tries to dodge one argument, they run directly into the other. It is an extraordinarily difficult position to defend against, and the early results prove it. Within 48 hours of this decision being published, attorneys filed at least 12 new federal lawsuits challenging similar reciprocity restrictions across the country. California, Hawaii, New Jersey, Maryland, Connecticut, Massachusetts, all of them are now facing direct legal challenges, citing this New York ruling. And every single one of those states is vulnerable for the exact same reason. The historical evidence the court uncovered doesn't respect state borders. Colonial-era protections for armed travelers applied across all territories. Pennsylvania's laws, Virginia's records, the founding generation's understanding of interstate movement. None of that was specific to New York. Lawyers challenging California's reciprocity ban can cite the identical historical sources. Attorneys going after Hawaii's restrictions, a state that also recognizes zero out-of-state permits, can deploy the same colonial records. The constitutional argument is universal because the historical principle is universal. The equal protection claim is even more portable. Every state that refuses to recognize out-of-state permits is creating the exact same unconstitutional classification. Every one of them fails strict scrutiny for the same reasons. Every one of them lacks compelling evidence that out-of-state permit holders pose a genuine danger. The legal template from this ruling works everywhere, and courts are already following it. A federal judge in California issued a preliminary injunction within 24 hours of this decision, citing the New York ruling directly. Hawaii faced a new lawsuit within 48 hours using the same equal protection framework. The dominoes are falling faster than anyone predicted, and there's an economic dimension accelerating this collapse that most people aren't tracking. Tourism industry analysis estimates that reciprocity restrictions cost New York roughly $850 million annually in lost visitor spending. California's losses exceed $1.22 billion from travelers who simply refuse to visit states where they cannot legally carry. Businesses are increasingly weighing firearms policies when making expansion and relocation decisions. When you layer massive financial losses on top of mounting legal defeats, anti-gun states face a brutal calculation. They can keep pouring taxpayer money into federal litigation they're increasingly likely to lose while hemorrhaging tourism and business revenue. Or they can accept reciprocity and join the 35-plus states that already recognize out-of-state permits without experiencing any corresponding increase in crime. Now, the practical reality for individual gun owners requires some important caveats. New York will appeal this ruling. That is a certainty. While the appeal is pending, the district court's decision stands unless a higher court grants a stay. 3 things to watch for in the coming weeks and months. First, whether New York requests a stay from the Second Circuit Court of Appeals. If granted, the ruling gets paused during the appellate process. If denied, it takes immediate effect. Second, whether other states facing similar lawsuits choose to settle rather than risk the same constitutional outcome. Some jurisdictions may calculate that accepting reciprocity costs less than fighting litigation. They're almost certain to lose. Third, whether this case eventually reaches the Supreme Court, and if so, whether the current court takes it up. The realistic prediction is that New York appeals the Second Circuit upholds the district court because the historical evidence and equal protection reasoning are too well constructed to overturn. And if the Supreme Court gets involved, the same court that ruled for individual gun rights in Heller incorporated those rights against the states in McDonald and created the historical analysis framework in Bruen is not going to suddenly reverse course and validate residency-based carry bans. The political fallout is already visible. Anti-gun governors are publicly pledging to fight this ruling with every available tool, which translates to expensive appeals funded by taxpayers that are increasingly unlikely to succeed. Their decades-old-long strategy of creating a patchwork of carry-free zones across America, making it meaningless in states like New York, California, and Hawaii. This ruling represents the first real crack in the legal wall that has kept those center state carry so legally treacherous that gun owners simply surrender and leave their firearms at home is crumbling under constitutional review. The historical analysis mandated by Bruen has made it nearly impossible to defend modern restrictions that have zero founding-era analog. The equal protection argument creates a second constitutional barrier with no effective counter. Anti-gun legal teams are being attacked from 2 directions with no viable defense for either. Over 4 million Americans hold valid carry permits that have been functionally permits powerless across state lines. The founding generation never intended for self-defense rights to evaporate at a state border. Colonial America specifically protected the armed traveler. The constitutional text, the historical record, and now federal court precedent all point in the same direction. Constitutional rights do not have geographic expiration dates. A federal court has finally said so in terms that cannot be ignored, and the legal shockwave is only beginning. That's it for today, folks. See you in the next.